When a company enters bankruptcy in the United States, its executory contractual commitments, that is, the commitments it has previously made via contract which are yet to be performed, may be placed on hold. A trustee is appointed in bankruptcy, and that trustee may elect to affirm a contract or to reject that contract. And if it rejects that contract, then the company cannot be forced to perform its executory obligations so long as it remains in bankruptcy. That's the reason that we often place source code into escrow with a third party, because if the bankrupt party is unable to perform ongoing software maintenance of the code, and it enters bankruptcy and the contract for maintenance is rejected, well, it can't be forced to perform those maintenance services. Those are executory commitments. Even if it has promised to provide a copy of source code should it enter bankruptcy, well, that's an illusory kind of promise, because if it's in bankruptcy and if the contract has been rejected, the licensee cannot force it to perform that executory promise, cannot force it to deliver the copy of the source code. Again, this is why we've placed the source code into the possession of a third party who is not subject to those bankruptcy-related restrictions and who can, upon the occurrence of an appropriate trigger, release the source code to the licensee. So Section 365N of the Bankruptcy Code has been created to provide some protection to licensees of intellectual property. Although a trustee may reject a contract, Section 365N says that a licensee may elect in that circumstance to retain its existing licenses in intellectual property. So if it is subject to an agreement with a licensor who becomes bankrupt, and if that agreement is rejected by the trustee in bankruptcy, then the licensee has an option. That is, an election to retain its license, or if it wishes not to, it can get into line with all the other creditors of the bankrupt party and sue for damages. Ordinarily, it will receive pennies on the dollar, something less than the damages that it might otherwise be owed, but that's its election. If, however, it retains its license, then it can continue using the intellectual property which it is licensed in our case, software. And that's why we would have a license in place for the source code, which it may obtain from a third-party escrow provider, and then may continue using that subject to a license that it has already obtained. Section 365N is therefore very important to acknowledge and to consider whenever we're putting escrow arrangements into place for a licensor and a licensee of software.